In 2020, the United States federal government passed the Anti-Money Laundering Act of 2020. Embedded in the act was the Corporate Transparency Act. The Corporate Transparency Act required a variety of reporting by companies that are registered to do business in the United States. So why are we talking about the Corporate Transparency Act in an estate planning seminar? Well, the reason for that is because the Corporate Transparency Act reporting requirements affect a number of estate plans out there. My name's Gregory Singleton. I'm an attorney with Signature Law, and we're here to talk estate planning. And today, we're going to look at the Corporate Transparency Act and how it might affect your estate plan. So, the basic principle of the Corporate Transparency Act is to require companies that are registered to do business in the United States to report their beneficial ownership information. The reason for this is the U.S. federal government wanted to prevent the formation of shell companies for the purposes of illicit activities such as drug trafficking, terrorism, money laundering, financial crimes, human trafficking, etc. Now, a lot of people in the United States are opposed to this sort of reporting. And in fact, that is one of the reasons why the Corporate Transparency Act was not effective until 2024. But being that it's 2024, it is now effective. So let's take a look at what those requirements are. The first thing we need to look at is who has to report. And to answer that, we're going to look first to what is a reporting company. And a reporting company is any corporation, LLC, limited partnership, or similar entity created by filing a document with any U.S. state, territory, or Indian tribe. And that's going to be a domestic reporting company. Or any non-U.S. entity that registers to do business with any U.S. state, territory, or Indian tribe, which is going to be a foreign reporting company. Now, what do these reporting companies have to report? Essentially, who their beneficial owners are. And a beneficial owner is going to be an individual who either directly or indirectly exercises substantial control over the reporting company, or who owns or controls at least 25% of the reporting company's ownership interests. Now, I highlighted there substantial control because that is going to include senior officers, such as president, CFO, CEO, COO, anyone with authority to appoint or remove certain officers or a majority of officers, major decision makers, or a variety of other people that are spelled out in the U.S. government's Small Entity Compliance Guide. The information that has to be reported is the information on the beneficial owners, which will be their full name, date of birth, address, which could be residential or business, their identification number, identifying number, which is their social security number or their tax ID number, and image of proof, which is going to be an image of a U.S. passport, driver's license, or identification card, or foreign passport if no U.S. document is available. And that can be a PDF or a JPEG that you actually upload onto the site. Company information that has to be reported, of course, is going to include the company name, any name that the company does business under that is not their registered name, their address, their employer identification number, their EIN, and who their beneficial owners are. Now, reporting is mandatory, and it has to be done at certain times. For example, if you're an existing company that existed before January 1st, 2024, you have until January 1st, 2025 to report. If you were created during 2024, then you have 90 days to report. And if you were formed after January 1st, 2025, then you have 30 days to report. And report you must because there are substantial penalties. Civil penalties are $500 a day that a violation continues, and criminal penalties can include fines up to $10,000 or imprisonment up to 2 years. So why does this matter in estate planning? Well, for a couple of reasons. First of all, some might think that once you create a revocable living trust, you've created an entity that is subject to the reporting requirements under the CTA. And I'm here to say, in Minnesota at least, that is not the case. Remember, the CTA only requires reporting by entities that are formed by the filing of a document with the state or the federal government. In Minnesota, we do not require people forming a revocable living trust, whether joint or solo, or whatever it may be, to form it by filing with the Minnesota Secretary of State. So we're safe on that front. However, look at cabins. A lot of times when we want to pass a cabin down from one generation to the next, we're going to put them into a cabin trust. And that will facilitate the transfer from one generation to the next, to the next, to the next, etc. Sometimes instead of a trust, for various reasons, we'll use a cabin LLC. Now, the cabin LLC might not generate any revenue at all or intend to in its entire existence. However, it is a business entity formed by the filing with the Secretary of State, and it is not subject to any exemptions of which I'm aware. So if you have a cabin LLC, make sure to do your filing. Also, very important to estate planning is small businesses. A lot of people have small businesses, whether it be a small store, or more often what I deal with are people that have rental properties and put them into an LLC. One of the dangers of that is, first of all, they are subject to the reporting requirements under the CTA. However, a lot of these owners of small businesses are not keeping up on the legal requirements that are out there, and they may get tripped up at some point. So be aware. I'm here to tell you, make sure if you have a small business, make sure to do your reporting. Also, another thing that's kind of a dangerous place. Imagine someone that put a business into a revocable living trust or just did a succession plan, and upon the owner's death, the business transfers to another person. This other person may not be aware of the reporting requirements under the CTA, and they could get tripped up as well. So that's a big area to watch and be aware of if you might be inheriting a business. Now, there is some litigation going on that is challenging the CTA. On March 1st, 2024, a federal judge ruled that the Corporate Transparency Act was unconstitutional. However, don't get too excited about this. This ruling only applies to members of the National Small Business Association in one respect. It waives their reporting. So if you're not part of that class, and your business doesn't fall into the class that is covered by this litigation, you're still required to do reporting. Now, on March 11th, 2024, the Department of Justice filed a notice of appeal on behalf of the Treasury Department that's escalating it up to the 11th Circuit Court of Appeals. Now, whatever happens at the 11th Circuit Court of Appeals, I anticipate this going up to the Supreme Court of the United States. That will take generally several years to go through the whole process. And even at that point, it might get remanded back down to the lower courts to be looked at again before it goes back up to the Supreme Court. This may take a while. And in that time, you're still obligated to report. So what action should be taken? Well, first of all, do your reporting. Do not assume that it doesn't apply to you without getting legal counsel and looking at the code and making sure it doesn't require you to report. There are exceptions. They are few and far between. And the litigation that is challenging the CTA is going to go on for some time before we have any ruling that affects everyone else. If you have an existing company, you have until January 1st, 2025 to do your reporting. I would say don't wait. Do not wait until December, or especially not until late December. Because once we get into December and late December, the servers are, mark my words, they're going to go down. And you're not going to be able to get through, and you don't want an internet problem. There's no exception that says if the server was down, you don't have to report. So you might get caught. One thing to be aware of, I'm sure this will happen. There will be companies, I've already seen them, companies that jump up and say, we'll do your CTA reporting for you. We'll do your BOI report and you won't have to worry about it. Don't fall for that. Doing the BOI report under the CTA is relatively painless and quite easy. You just need to get the information ahead of time. So rewind this video, look at the information, prepare it, you're good to go. And you can do the report yourself. You just go to fincen.gov, fincen.gov/BOI. So that is my take on the Corporate Transparency Act. I hope you liked today's video. If you did like today's video, please be sure to hit that like and subscribe button. It really helps support the channel. If you have questions, leave them in the comments below, or if you have ideas of things you want me to talk about, happy to do so. We're doing videos a couple a month these days. Until next time, this is Gregory Singleton with Signature Law.